Good afternoon. Welcome to our New Leaf webinar. In a moment, I'll introduce our presenter, but I wanted to share a few logistics. First, if you have questions, you can enter them in the question feature in the control panel. The control panel may have slipped off to the right, but you can bring it back out to type in a question. I have two handouts uploaded here, and they are handouts about the rental assistance program available for people who are having trouble paying rent. And the applications for that are made by landlords, and the portals will open, I believe, on May 17th. So we wanted to share information about that. And a survey is going to launch at the close of the webinar so that you can give us input on how we did with this webinar, whether it was helpful, and what suggestions you have for us going forward. And with that intro, it's my honor and privilege to introduce Lacey Burpee. She's a staff attorney in our Waukegan office, in our records relief projects and our New Leaf project, and she coordinates those projects. And I think you'll find the information she has to share this afternoon really helpful. So Lacey, you're on.
Thanks, Linda. Hi, everyone. As Linda said, my name is Lacey. Thank you for joining me today to learn more about the new cannabis law. Next slide, Linda. So I want to start with a little bit of information just in general about Prairie State. We provide free civil legal services for people who are low income and over age 60 who have serious civil legal problems. And we also assist clients of varying incomes with issues like domestic violence, fair housing, and with this issue, cannabis expungement. So please visit our website to see if you or someone you know may qualify for our services, as our eligibility guidelines may be broader than you would expect depending on what type of case it is. We serve the northern half of Illinois with the exception of Cook County. And please note that while we're talking a lot about the law today, what I'm providing is not legal advice because it isn't tailored to your unique situation. And some of these issues are quite complicated and really depend on what's going on. I know we also have a lot of social service providers on the call today, and we're so happy to have you. This information that I'm giving is intended to help you spot issues and problems that your clients have so that you know when to refer them to New Leaf or to our office. So please don't try to assess your client's situation on your own or provide advice based on the presentation. That's what we are here for. So if you have someone with an issue, please send them over to us. Next slide. So what is New Leaf? New Leaf is a group of agencies across Illinois who are funded by the state of Illinois to help people who want to expunge their prior cannabis records. Cannabis is legal now, but the records can still cause problems if they're visible. Next. I want to talk about a few different things during our time together today. First, I want to talk generally about the new cannabis law. Then we'll talk about how it impacts many other areas of law, including employment, housing, disability rights, and immigration. And then we'll segue into expungement of cannabis records and the resources and next steps that you can take if you're interested in obtaining this relief. And then I want to end with a brief overview of sealing and expungement just in general, because none of this happens in a vacuum. For many people, the cannabis record may not be the only criminal record on their background. So just getting rid of that cannabis case may not really have a big impact on their life if other cases are still visible. And there are other remedies in the law to help even if there aren't any cannabis cases on someone's record. Okay, we're going to be at our first poll. All right, so cannabis is now legal. So who can limit my use of cannabis? Choose any or all that apply. So no one, it's legal. 2, my landlord. 3, my condo association. 4, my employer, or 5, the state government. I think a poll should be popping up in just a second, so please share your answers.
So this is great. I see lots of votes coming in. I'll give you a last call when we get about 3/4 of the answers in.
Great, thanks, Linda.
And are you seeing the poll, Lacey?
I see the poll. It says poll in progress for attendees only.
Okay, great.
So I don't get a vote.
No, you don't get to vote. Hopefully you know the answer.
Hopefully. We'll find out.
All right, well, let's do a last call. So put your answer in. You want to be heard here. Okay, we had almost everybody, so apologies if you weren't quick enough. Are you seeing the answers, Lacey?
I am. So we got a lot of good answers in here. And we're going to talk about how actually all of those people and entities that are listed, the landlord, condo association, employer, and the government can in fact still limit the use of cannabis. So even though it's legal, there are still limits and things that people need to be aware of to make sure that they aren't getting into trouble with using it. So let's go on to the next slide and start talking about kind of the big picture of the new law. So cannabis is legal now, but there are still rules about who can have it, where they can have it, and how much they can have. So only people who are 21 and over can possess and use cannabis, and the amount is not unlimited that someone can have. An Illinois resident can have 30 grams of the cannabis flower, 500 milligrams of THC, and 5 grams of cannabis concentrate. And these numbers are cumulative, which means that someone can have that much of each thing and still be in compliance with the new law. For non-Illinois residents, however, those amounts are cut in half. So if Cousin Joe comes to visit from out of state, say he drives down from Wisconsin, he can only have half of the amount that someone who lives here can. Next slide. So on this last slide, we talked about what people can do under the new law. And now, oh, actually I have another poll. I forgot about my poll. So I want everybody to take a look at all these statements and select all of them that are true. So 1, expungement is automatic. Any cannabis related case I have will disappear without me having to do anything. 2, no one can stop me from smoking cannabis in the privacy of my own home. 3, I no longer need to buy cannabis because anybody can grow their own. 4, cannabis cases are causing problems with my immigration application, but now the cases are expunged, my problems are solved. Or 5, I can apply for help with my cannabis-related criminal records by going to newleaf.org, newleafillinois.org. So give everybody a minute to pick all of the ones they think are true.
Okay, we've got about half of you have voted, so we'll let the other half have a few more seconds to put in your opinions. Okay, last call if you want to vote here.
All right. So we have a smart group of people who know that you can go for help to newleafillinois.org, and that in fact is the only true statement on this poll, and we're going to talk starting now about some of the things that you can't do and some of those limitations on cannabis possession and use. So we talked about what you can do. Let's talk about what you can't do. You still can't drive while under the influence of cannabis. That's still a DUI, driving under the influence. And it can lead to the loss of a driver's license. So it's pretty serious. Cannabis also can't be used in public places. It can't be used around minors, even if it's in your own home. And a landlord and condo association can have rules and regulations surrounding the use of cannabis in many cases. It's also important, if someone's driving with cannabis, that it's in a sealed container and reasonably inaccessible while the car is moving. And this is a new law, so a lot of the nuances for these rules are still being figured out. But this in general is some of the things you can't do. So next slide. So the first thing I want to talk about is personal cultivation. And this was one of those options in the poll before. So cannabis is legal. Everybody can just start growing their own now, right? No need to buy it anymore. Well, unfortunately, no. That is not the case. You can only grow cannabis if you are a registered qualifying patient with a medical cannabis card. Everyone else needs to purchase their cannabis from a dispensary. So to grow medical marijuana, a person also has to be 21 years or older, and they have to be an Illinois resident. So once again, it cannot be grown for personal use. Only someone with that medical card for medical purposes can grow it. So let's go back to Joe. Joe is now an Illinois resident, and he is a medically registered qualified patient with that medical marijuana card. And he has a very green thumb and grows more cannabis than he knows what to do with. Can he give some to his friend Seth, who uses cannabis to ease his anxiety? Not unless Seth has, or you know what, he cannot. Even if Seth has the medical marijuana card, Seth would need to grow his own cannabis. Joe also can't give Seth any plants. The plants and seeds have to be purchased from a dispensary. For someone that is legally able to grow plants, they have to be grown in a space that is enclosed, locked, and secure from unauthorized access, and it has to be outside of the ordinary public view. Landlords can put in the lease that growing cannabis is not allowed on the property, and renters in a federally subsidized unit are never allowed to grow cannabis on the property. So next slide, please. So let's talk a little bit about how cannabis can impact housing. And if you want to go to the next slide, Linda, we're going to start by talking about the rules for someone living in public housing. So it's really important to remember that even though cannabis is legal in Illinois, it's still illegal under federal law. So using or having cannabis for someone who has a federally subsidized housing unit or voucher can lead to an eviction and the loss of that housing subsidy. And this not only applies to the person who has the voucher or housing unit, it also means that guests can't use or possess cannabis on the property either. Also, there is just a general smoking ban in federal subsidized housing. So not only is it a problem that it's cannabis, smoking cannabis would also run afoul of the regulations just to not have any smoke, whether it's cigarette or cannabis or e-cigarettes. Next slide. So that was for private house or public housing, and now let's move on to private housing. So I'll start with the good news for renters who are using cannabis. Private rentals have different rules than federally subsidized units, so there's not an absolute bar. And landlords can't be penalized under Illinois law for renting to someone who is legally using cannabis. But there still might be some limitations. A landlord can restrict cannabis use if it's in the lease. So just like a landlord can impose a smoking ban in the lease, the landlord can also limit the possession or use of cannabis inside the unit. And if someone is using cannabis in violation of their lease, it could lead to an eviction. It's a little bit different if somebody has a medical marijuana card. The landlord can still put in the lease that smoking cannabis is prohibited in the unit, and they can stop the renter from growing cannabis in the unit. But if a renter has that medical card and is that registered user, then the use of other forms of cannabis cannot be prohibited by the lease. Condo associations can limit smoking in individual units, but they can't limit the use of other forms of cannabis. But the condo association cannabis can stop owners and people living there from using cannabis in any of the common areas. If you are not an owner in a condo building, but you're renting from an owner, it's important to remember that a landlord can always have rules that are stricter than the condo association. So if an owner in unit 1 is allowed to smoke cannabis in their unit because it's fine under the condo rules, that doesn't necessarily mean that a renter in unit 2 can smoke cannabis in their unit. They would need to look at the lease they signed with the landlord to make sure that the lease doesn't prohibit smoking cannabis in the unit. Cannabis also can't be used around minors, even in someone's home. So even if it would be otherwise okay to use cannabis at home, it isn't allowed if there's a licensed child care on the property, if there's foster care or similar social services that are on the premises. Next slide. So let's talk a little bit about some protections that are available for people with disabilities under this law. Next slide. So first, I want to note that the Americans with Disabilities Act, so the federal law that often provides a lot of protections for people with disabilities, does not apply in many cases. It doesn't apply to people who are currently using cannabis because cannabis use is still illegal under federal law. There are some protections for people who used to use cannabis but don't anymore, if they can show that they went through treatment or have been rehabilitated successfully. In practical terms, the Americans with Disabilities Act doesn't provide protection against an employer asking about or testing for current cannabis use, but it may provide some protection for against the employer asking about things related to that past drug use. Next slide. So in order to find some protections, we really need to look at Illinois law because cannabis is legal in Illinois, unlike under the federal law where it's still illegal. And there are a couple different ways that the Human Rights Act may provide protection. It might provide protection when someone experiences disparate treatment as a result of their cannabis use, or if they are denied a reasonable accommodation to an employer's drug-free workplace. So, there are a lot of terms in there that are still being figured out because this is a new law. What is reasonable for an accommodation to an employer's drug-free workplace? It depends on a lot of things, including the type of job and the employer. And I want to remind everyone that, this law is very new. So we haven't really seen how the courts are applying this in real life. Next slide. And then the last place I want to talk about in the law that might provide some protection is the Compassionate Use of Medical Cannabis Act. And this is the law that allows qualified people with certain disabilities to register and get a medical cannabis card. So this is someone who also would be able to grow cannabis in their unit. Employers cannot penalize someone with the medical cannabis card, but the employer can still conduct drug testing, and they can still have a zero tolerance or other drug-free workplace policies. So employees, even those with the card, can be disciplined for failing to follow the employer's policies or failing that drug test. So we're also waiting to see how the court is going to interpret this law. So we will, hopefully have more information as time goes on and the courts start making decisions on this. Next slide. So the next area I want to talk about is employment law. And you can go right on to the next slide, Linda. So even though cannabis is legal, it can still lead to problems with employment. You don't have to tell your employer about using cannabis when you're not at work and when you aren't working, but you can be fired if you are using cannabis or you're under the influence of cannabis, if you have it on you when you are at work or if you're working. Next slide.
We're sort of losing your
And the employer can still do drug tests, and that includes testing for cannabis if it's.
Lacey, you're popping in
Yes.
and out. Do you want to go back to what you started to say on this slide? Because I think we missed.
Oh no.
We missed your first words on this slide.
Sure. Sorry about that. Okay. Can you hear me? Can you hear me better now?
Yep. So far, so good.
Okay. Okay. Sorry about that, everybody. So let's start over. Let's see. So the employer can still do drug tests, and those drug tests can include cannabis if it's part of a reasonable drug-free workplace policy. However, a person can't be fired just because they test positive for cannabis. The employer also has to show that that person was impaired or under the influence of cannabis. So the employer has to give the employee a chance to contest that finding, that they were under the influence after that positive test. Although Illinois law may provide some authority for the employer to provide an accommodation for medical marijuana use, that's what we were just talking about a couple slides ago. It's unclear how this will all work out and how strong that protection is, because under federal law, there aren't any protections and cannabis is still illegal. So we need to see kind of how the courts are going to treat this. Next slide. All right. So for most jobs, sealed and expunged cases are considered non-convictions. And the Illinois Human Rights Act protects a person whose records are sealed or expunged from having to tell their employer about those records. And even if a record isn't sealed, there have been some recent changes to the Illinois Human Rights Act that provide that an employer can't refuse to hire someone and they can't take adverse employment action just because that person has a record, even if it's a conviction, unless the potential employee or the employee who is having that negative action taken against them has a chance to correct any mistakes in a background check or explain the record or conviction. The employer needs to look at several factors and tell the employee why they made the decision if they decide that that record is serious enough that they can still take that adverse action or not hire them. That is also very new, so we're waiting to see how that kind of plays out in practice. Next slide. And moving on, I know this is a lot of information about a lot of different areas, but it's all very important. You know, cannabis can have a really big impact in so many different areas. So I want to talk about immigration next. So go ahead and go to the next slide, Linda. So remember, I've said this quite a bit. Cannabis is still illegal under federal law. And this is another one of those areas where it can have a really big impact. There can be serious consequences for non-citizens who benefit somehow from the cannabis industry, or even who use or possess cannabis, even if it's legal in the state. So it's legal in Illinois, but it could still be a really big problem for non-citizens. A non-citizen can be denied entry into the United States. They can be denied an application or permanent residency. They can be subject to detention or possibly deported if the government finds out that they were using or possessed cannabis. Next slide. So this applies even if the person has a medical cannabis card. So just having that card isn't enough for the federal purposes. It's still illegal under federal law with the card or not. So it's really important to talk to a trusted immigration attorney before getting that medical cannabis card, carrying the card, traveling with the card, or talking to an immigration officer or consular official about anything related to cannabis, even if it was for a medical purpose. Someone who used cannabis or worked in the cannabis industry may not be able to get back into the United States if they were to leave and try to come back. So this can have some really serious consequences. Next slide. All right. So we're going to hold off on the poll for just a moment. So expunging or sealing criminal records will not solve an immigration issue related to that case. And once again, we strongly recommend talking to a trusted immigration attorney before sealing or expunging any cases. Otherwise, it could create additional complications for immigration purposes. Under the new law, though, some of the cases are going to be automatically expunged. Some of those cannabis cases are just going to...
Oops, we lost you again. You
it may
said
not
automatic.
disappear, which for most people is really good, but in some cases, like this, it may not be so good. So there are...
Lacey,
Oh,
you're
cutting
coming
out,
in
Linda.
and out again. You're coming in and out again.
Oh no. Oh no. Can you hear me again?
Yeah, you were fine through the last comment on the immigration, but when you started to talk about the poll, we lost you.
Okay. I skipped ahead to the poll and I still had a couple things to say about immigration. So if we wanted to go back to the other slide just really quick. Okay. So can you hear me okay again?
Yes.
Okay. So expunging or sealing a criminal record is not going to solve an immigration issue if there's an immigration issue related to that record. We strongly recommend talking to a trusted immigration attorney before sealing or expunging any cases. Otherwise, it can create additional complications for immigration purposes. But under this new cannabis law, there are some cannabis cases that are going to automatically be expunged, which for a lot of people is going to be very helpful. For some people in the immigration context, it's not going to be so helpful. So there are some steps to take if you aren't a US citizen but have a cannabis record. So the first thing to do is to get 3 to 4 copies of the court record, including a certified disposition. And that provides documentation about what happened in the case if it's needed later. So it's best to do this as soon as possible before the case is expunged because you can get the full records. But if the case is already expunged, the clerk of the circuit court, wherever that record was, should still provide a copy of the certified disposition of that case to the person who the record belonged to if the person requests it, even after it's been expunged. So now we can move on to the poll. Okay, so we're going to move on to talking about expunging cannabis records. So let's start off with a little story about Judy. Judy applied for an apartment a couple weeks ago, and everything was going great until the background check her landlord ran came back, and her cannabis conviction from a decade ago was still showing up. The landlord decided to rent to somebody else. Shouldn't that case have already been automatically expunged? And then you all get to pick the right answer. One, the case may have been missed because law enforcement records can be incorrect or incomplete. It may not have qualified as a minor cannabis offense, and it wasn't the type of case that qualified for automatic expungement. The case may still have been in the process of being automatically expunged, or the expungement pardon may have been denied by the governor. And you can pick more than one if you think more than one of those might be what happened.
People are doing great. We've got about half the people have responded. So we'll wait just a little bit more and let a few more people respond.
Great, thank you.
Okay, last call.
All right, we have another question that shows how smart our audience is. All of those could have been correct. Any one of those things could have gone wrong, and we're going to talk about each of those in more detail. So let's move on to the next slide. Oh, you know what? There was my missing slide. So I already talked about that. We can go forward. All right. So there has been a lot in the news about the automatic process for the expungement of these records. So, you know, if it's automatic, why are we even talking about it? It should just be done. Do people still have to do something? And in many cases, the answer is yes. And we're going to talk about the steps that someone needs to take to make sure that their full record is expunged. We're going to talk about the types of cases that are eligible and the 3 ways that the records can be expunged under the new law. So the first is the automatic expungement of law enforcement records. So that's the expungement of arrests that didn't end up as a conviction. The second process is the pardon process for minor cannabis offenses. This one's somewhat automatic, and it provides for a possible pardon and expungement of some cannabis convictions. And if that's successful, the person with the record doesn't have to take any additional steps. It's really important to understand that there are many cases that are going to be missed or aren't going to qualify under those first 2 procedures. Cases can be overlooked. They might be denied somewhere along the process, or they could just not qualify. There's a third process that is for people who can't get relief under those first things we just mentioned, or for people who need faster relief because those automatic processes are going to take time. So that third process allows people to petition the court to vacate and expunge eligible records on their own. Next slide. So that first category of relief for someone with a cannabis record is the automatic expungement of a law enforcement record. So the only thing that's going to disappear from this process is the arrest record that the law enforcement agency has. If there was a case that was filed in court, even even though it was dismissed or not a conviction, that court record is still going to stay in public view unless the person takes action on their own to expunge that record. And it's only for certain cannabis offenses called minor cannabis offenses. So once again, this is for arrests, and that arrest could not have led to a conviction. If the arrest ended up as a conviction, that arrest is not going to be expunged. It's going to stay visible. And it's only for minor cannabis offenses. And a minor cannabis offense is, in general, a small amount of cannabis, less than 30 grams for a possession case, or less than 10 grams. 10 grams or less, I guess, for manufacturer delivery. And there can't be a penalty enhancement or an associated arrest or charge for a violent crime. So even if it was a low-level offense, there are a couple things that could have been happening in the background of that case that would make it still not eligible. So, just a quick overview of what an enhancement would be. A penalty enhancement is added to the charge when someone who is over 18 is selling to a minor, so someone under 18, and that minor is 3 or more years younger than the seller. Okay, next slide, please. So I have a chart that goes into quite a bit of detail about this process. It's in the handout that was sent to you. Just going to go over kind of the big takeaway, which is one, this process is only for arrests that didn't end up in a conviction. So remember, any court records that were created are not expunged in this process. Those remain publicly visible. It only applies to some types of cannabis cases, and this all starts with the Illinois State Police looking through their records to find qualifying cases. So if their records are incorrect, or if they're missing information, an arrest that should have been eligible might be missed. Next slide, please. So the next process is the cannabis pardon process. And this process works a little bit different from a traditional pardon. The person with the cannabis record doesn't need to apply for the pardon. They don't need to take any steps to start the process. But it also is not automatic and guaranteed that the expungement will be granted at the end. Also, just like in that first process we were talking about, it also doesn't cover every single cannabis related case. It is only for minor cannabis convictions. So let's go to the next slide and take a closer look at this process. So this is dealing, that last process we were talking about was for the arrest records. This next process is for court records. So the first thing that someone should do if they think they may qualify for this pardon is to update their address with the circuit clerk of the county where the conviction was, because nobody is going to tell you that this is happening. The governor is not going to tell people that the pardon was granted or denied. The court isn't going to tell you that a case was filed to expunge that record, but a copy of the expungement order can be requested after the record is expunged. So it's important that the clerk has the right mailing address to get it to the right place and the right person, not an address from a decade ago where someone else is living. So, the big takeaway from this is also expungement isn't guaranteed. There's a lot of places where, things might go off the rails. That case might be missed when the Illinois State Police are looking for eligible cases. After the Illinois State Police look for eligible cases, they send what they find over to the states or to the Illinois Prisoner Review Board. And there may be objections from the state's attorney on some of those cases, and the review board may not recommend a pardon be granted, and the governor may not actually grant the pardon. So if the governor doesn't grant the pardon, the case isn't expunged. This process also takes quite a bit of time. Even if a pardon is granted, the attorney general still needs to file with the court to get the record expunged. So in this process, there are a lot of different people involved and a lot of different people making decisions. So just because even if the record is caught during step 1, there's no guarantee that it's going to make it all the way through this process and be expunged. Next slide. So there is some good news for people who were either left out of the first 2 automatic processes or their case was missed somehow or it's taking too long. Even though this next process isn't automatic, a person with a qualifying cannabis record can ask the court to vacate their conviction and then expunge the qualifying cannabis record. This process might be faster than automatic relief. This process still can take quite a while, but it may still be faster than automatic relief. And it provides eligibility for some slightly more serious cases that don't qualify for automatic relief. And it also allows people to get relief on cases that were otherwise missed or rejected in the automatic process. And I do want to note that, you know, those automatic processes are happening now, and we're not sure how long those are going to actually take. So let's see. Instead of so another reason that this third process can be better for some individuals is it isn't just for minor cannabis convictions. It's for some cases that are a little bit more serious. So for the minor cannabis convictions, the person could only have possessed up to 30 grams in a case. Under this, they can possess up to 500 grams. For dealing, they could have 10 grams or less under the minor cannabis. But for asking the court themselves, they can have up to 30 grams for dealing. And there's no limitations for those enhancements or violent arrests or charges. Next slide, please. All right, so for this process, it really is on the individual to take all of the necessary steps to make this happen. And this one also isn't guaranteed. You know, it's always up to the judge at the end of the day whether or not he's going to grant that motion to vacate and expunge. But the first step in this process is to get the case into court, and it has to be filed in the court where the record happened. So if someone has cases in 4 different counties across the state, then they're going to need to file 4 separate motions to vacate and expunge those qualifying cannabis records in those separate counties. You can't just do it in one county. Fines and fees that are still owed on those cases don't need to be paid off, but if there's any other sentences or conditions of that case, those should be completed before filing to vacate and expunge the record. The court clerk lets the state's attorney know about the case, and the state's attorney can object to the petition. And then there's a hearing in front of the judge, and the state's attorney, if they've objected, will say why they think the record should remain public. And the individual with the record gets a chance to explain why they think the record should be expunged. And the judge considers things like the reasons to keep the record as provided by law enforcement, how old the petitioner is now, how old they were at the time of the offense, how long has it been since the conviction, and the specific consequences that will happen to the person if the judge denies the petition. And the judge always has, you know, the ultimate yes or no. At the end, expungement is never guaranteed. Next slide, please. All right. So if you or someone you know wants help learning about whether or not they qualify for the motion to vacate and expunge and potentially get free legal representation, New Leaf, Illinois has an online registration at newleafillinois.org, or they also have a phone number that you can call or have your client call, and they can provide advice and then a referral to whichever legal aid agency across the state is helping people with records in that particular county. And this statewide helpline has referrals to partner agencies like Prairie State. So we're one of those partner agencies. So if it's in our service area and the person qualifies for our services, we might be able to provide full representation. Next slide, please. All right, so we have another poll. So we've talked a lot about what to do if someone has a cannabis case. What should I do if I have other non-cannabis cases? Should I give up? Should I try to hide them from my employer or landlord because it isn't any of their business anyway, or ask the court to seal or expunge my records?
And while people are answering this poll, just a reminder, if you have questions for Lacey, you can put them in the question log, and Lacey will answer them at the close of the program. So last call if you want to answer this poll.
All right, we have, once again, such a smart group of people. We should ask the court to seal or expunge the records. Giving up, no one wanted to give up, and only a couple of people wanted to hide them from the landlord or the employer. So let's talk about what sealing and expunging these non-cannabis cases looks like. So next slide. So these cannabis cases don't really happen in a vacuum. For some people, the cannabis record may not even be the most serious case on their background, and it may not be the case that's causing the most problems. So, what can they do if they have other records? The law allows most criminal records to be sealed or expunged. Sealing is for convictions, and it's going to remove those records from the public view with just a couple exceptions. Expungements are for non-convictions, and those records are destroyed or permanently impounded. So they're a little bit different. We're going to talk about why, but both of them make it so that the general public aren't going to have access to those records anymore. Next slide. So expungements are what we're going to start with. Those are for non-convictions. In a non-conviction can be an arrest where it never even got to court. It can be where it got to court, but the case was dismissed, or it was nolle prost, or stricken with leave to reinstate, which are just fancy ways of saying that the state's attorney decided for whatever reason not to move forward on the case. So the case went away, but it's still there. It still shows up on the public record. And it also applies to some special non-conviction sentences. So sometimes, even if someone is sentenced in a case, if they're sentenced to something called supervision or a qualified probation, not all probations, but a qualified probation, and everything in those was completed and it was terminated satisfactorily, then those are also legally a non-conviction, even though there was a sentence in the case. That can be really confusing for employers and landlords, because it looks like there was a case, it looks like there was a conviction, but legally there wasn't. There is an exception for minor traffic violations. Minor traffic violations, even if they're dismissed, are going to stay on someone's record. Those are usually not what is holding someone back. Next slide. So so we talked about what kind of records can be expunged. So when can they be expunged? A lot of them can be expunged immediately. So an arrest, when no charge, those dismissals, the state not moving forward, those can be done right away. some of those non-conviction sentences where it looks like there was a case in a sentence, but legally it's not a conviction. Those are going to be between 2 and 5 years before someone can ask to have those expunged. And it's 2 to 5 years after the completion of the supervision or qualified probation ends. Next slide. All right. So let's move on to sealing. Sealing is for convictions. It's going to remove those cases from the public view. So people that are still going to be able to see those, law enforcement, the court, and employers who are required by law to run a fingerprint background check, but they can only see felony convictions. And they're going to see that it's sealed. It may or may not be a bar. Next slide. All right, just give me 1 second. Excuse me. All right, so let's talk about the different things that can be sealed. So the first is a non-conviction. And you might be asking, why would you want to seal a non-conviction instead of just expunging it? Because expunging seems better, right? It's destroyed or permanently impounded instead of the court and law enforcement still being able to see it. And that is a great question. And the reason that's available is one, it's in the law. But practically speaking, sometimes a judge is only willing to seal a record. Sometimes they don't feel comfortable expunging the record for whatever reason. We see this happen most often with domestic battery related records. Even though a domestic battery has been dismissed or nollied, the court may only be willing to seal it, which is still more protections than if it were in the public view. Most supervisions and qualified orders of probation, those are also going to be able to be sealed. And this includes cases that have been unsatisfactorily terminated. So for expungements, everything had to be completed. It had to be satisfactorily terminated. This one, it doesn't matter what ultimately happened in the case. Even if it was unsatisfactorily terminated, it would still qualify for sealing. Most convictions, misdemeanor and felony convictions, are eligible for sealing. So let's move on to the next slide. All right. So the law allows for most types of cases to be sealed. And we used to talk about, what cases were eligible a few years ago. And then the law changed and it really expanded what cases were eligible. So now it's easier to talk about the things that are going to stay on someone's record until the law changes, the things that are not eligible. So things that aren't eligible right now, most sex crimes, DUI, reckless driving, convictions for violations on an order of protection or civil no contact orders, dog fighting, animal abuse, battery of an unborn child, and domestic battery related cases. I mentioned before under expungements, minor traffic violations are also not eligible. So rolling through a stop sign, gonna stay on your record. But more serious cases that are charged as misdemeanors, like driving on a suspended license or revoked license, might be eligible. Next slide. So there's usually a waiting period before someone can seal their case. And for most non-convictions, the person can usually request the record be sealed right away. It's the same with expungement. There's no waiting period if a case was dismissed or something like that. Sometimes a waiting period can also be waived. So if someone completes a career certificate or an educational goal during their last sentence, for example, someone who gets their GED during their most recent criminal sentence doesn't have to wait before asking the court to seal their records. They just have to wait till the end of their case, and then they're immediately eligible. If someone has successfully terminated their supervision, they have to wait 2 years from the time that that supervision ended. This is the same waiting period as the expungement. And for all other convictions, or if someone had a satisfactorily terminated qualified probation, that would be eligible for expungement in 5 years. The waiting period is 3 years after the termination of that person's last sentence. So let's go to a poll to kind of talk a little bit more about waiting periods. So let's talk about when Joe is eligible to ask the court for criminal records relief. Joe's last case, or last criminal case in Illinois was in 1992. He went to Florida a few years ago, and while he was there, he got a DUI. He was celebrating his recently earned master's degree. His probation in that case ended in June 2020. And he also unfortunately just ran a stop sign last week and has court in a few days. So when can he ask the court to seal his Illinois cases? One, now. The Illinois cases are almost 20 years old. Two, he can waive the waiting period because he got his master's degree. Three, he needs to wait and see what happens in that traffic case, so we don't know. Or four, in June 2023, 3 years after his case in Florida ended.
And I'm just laughing, Lacey, because I looked at this poll so many times, and those cases are actually almost 30 years old.
Oh, well, there's my math.
Well, I didn't get it until just now. So we'll see if that tricks people up. I think this is our hardest poll because the answers are coming in more slowly.
This is definitely our hardest poll.
So we have about half the answers in. We'll just wait another 10 or 15 seconds.
And I purposely made a couple of these a little bit tricky.
All right, we'll close it out and we'll see what people had to say.
All right, so we have kind of a mix of answers. Can they all see the breakdown, Linda? Or just me?
I think that everybody sees it.
Oh, okay, great. So let's just go down the list one by one and talk about them a little bit. So the cases in Illinois are, as Linda said, almost 30 years old, not 20 years old. However, that waiting period is triggered by the person's last criminal case anywhere, whether it's in Illinois or around the country. So that DUI in Florida is going to trigger that 3-year waiting period again. So if he hadn't gotten that DUI in Florida and he just had those 2 cases in Illinois, he would be well beyond that 3-year waiting period. But since he got that Florida case, he's got to wait another 3 years until after his sentence ended. I threw in that he was celebrating his master's degree because sometimes if someone gets that educational degree during their last sentence, they don't have to wait. They can waive that waiting period, but they have to get that certificate during their last sentence. So he got it before he got his criminal case. So that doesn't apply either. He's stuck with the waiting period. The traffic case was also thrown in there to throw you off. Minor traffic cases can't come off your record, but they also don't impact someone's ability to seal. So if he had been pulled over for driving on a revoked license. Maybe his license was revoked for the DUI. If he was charged with a misdemeanor, and it looked like a more serious case, that might be a problem. He might need to see what happens with it. But that minor traffic case isn't going to trip him up. So the correct answer is June of 2023, 3 years after his case in Florida ended. So let's go on to the next slide. All right. So just a couple last notes on sealing and expungement in general. This first one also applied to the cannabis records. It's always the judge's decision whether or not to grant relief. The judge can always say yes or no. At the end of the day, these petitions, are not absolutely guaranteed. So that is important to remember. Also, if a person has felony records and they get them sealed, he or she can't have subsequent felony convictions sealed if they were convicted after the date of the sealing. If they're convicted again for another felony, not only do they not get another chance to seal those later felony records, the court can also unseal the previously sealed felony records. So it's really important that once this remedy is granted, there aren't those additional criminal records cases. So next slide. I think we're at the end. So if anybody has questions, type them in quickly. Thank you for joining us today. So my information is on the slide as well as our website. I think we had people joining us from all over our service area. So this is the phone number to the Waukegan office. You can find the local office number to call at our website or apply online for services. If you or your clients would like help with a cannabis case in particular, I would encourage you to apply through newleafillinois.org or use that phone number. It will go through CARPLS, which is another legal aid organization, to provide advice, and they will make sure to refer the case to whichever the appropriate legal aid agency is, depending on where that record is located. So I look forward to helping anybody on the call that needs help. And if anybody has any questions, please let me know.
Okay, we do have a few questions, and I know some people need to leave us. So just a reminder, the 2 handouts you can download on the rental assistance program, which is going to be so important for preventing evictions. And that a survey about this webinar will launch when you log out. So one question, Lacey, is Prairie State or any other organization you know of litigating use of cannabis as a reasonable accommodation under the Illinois Human Rights Act? That's a long question. Or appeals in order to establish precedent that interpret the law more broadly?
Prairie State is not that I'm aware of. I'm not sure if any of the other agencies have any active litigation. I know that there are a group of agencies that belong to New Leaf, and some of them do work more exclusively with those issues, and I know that they're kind of on the lookout for those issues. I'm not sure if anyone has found any cases yet or where those are in the system. But it's on everybody's radar to keep an eye out for those issues.
And Prairie State does have a fair housing project, so I can't speak for what particular issues those attorneys have seen so far.
Mm-hmm.
So that project serves just, I think, a small number of our counties out of the Peoria, Bloomington, Waukegan, and Rockford offices. So there is a question, will you send the PowerPoint? I, in fact, sent the PowerPoint yesterday afternoon, I believe, to everyone who had registered at that point. So if you did not get the PowerPoint, look in your spam folder or email meetings@pslegal.org if you're one of the people who registered late in the process. Someone says that the website is unavailable, technical difficulties, ? I don't know if that's the New Leaf website or our website.
I will do a quick check. Did I think I typed our website right?
I think you did too.
I hope. That would be embarrassing.
So, Lacey, while you're doing that, hopefully you can, do another task at the same time, multitask.
Yeah, both are popping up for me.
Okay. Okay, great. So whoever asked that question can try again. Do people need to refer their clients to New Leaf first, or can social service providers refer their clients directly to Prairie State, to the local Prairie State office for the assistance on expungement for cannabis?
So, sure. So you're welcome to refer them directly to us, especially if you know where their record is, and the record is in our service area. If there's any confusion about that, if they have records in other places, or if it's someone who maybe you think may not qualify for Prairie State, but could really use at least some advice. New Leaf is a good resource to get people where they need to go, and they provide advice without any income limits at all. So for this grant, we have our income eligibility is a little bit broader than some of our other grants, but we still do have some limitations. New Leaf does not. So if you send them to New Leaf and they're appropriate for us, they will end up getting to us. But if that's going to be too much for your client, you're also welcome to send them directly to the local office. Also, if the person just has sealing and expungement and there's no cannabis record, send them directly to us. If there are any eviction issues, anything, any other type of case we might handle, just send them directly to us.
So someone is asking, Lacey, is there a way to tell on a court's docket sheet whether a cannabis conviction has been pardoned through the automatic pardon process?
It won't be there anymore. Is about the only way. So the longer answer is, I'm not sure what it's going to look like and if it's going to look different in different counties. What's going to happen is once the pardon is granted, in the process through when the pardon is granted is confidential. You can't FOIA the information, you can't get it, they're not going to tell you anything about it. Once the pardon is granted, that information is sent to the Attorney General. The Attorney General is going to file to have the cases vacated and expunged. But I'm not sure how they're going to file those and how those are going to show up on the docket. They were talking about filing them. I don't know what, I'm not even going to speak to it because I don't know enough of what was happening. I know that they were trying to figure out the best, most efficient way to do this because it's going to be large batches of cases. So I don't know if the clerk is going to update all of those court records while that's happening, or if it's just going to be there one day, and if it's granted, it's going to disappear the next. So if someone checks it and it's not there, the pardon probably went through.
Okay, so
I know, not a great answer.
We'll take just a couple more questions. Someone asked, can a domestic that is nolle prost be sealed or expunged?
In general, that is the type of case, that is a type of case that would qualify for expungement. I would say that someone would need to look at maybe some of the other context, but a nolle domestic battery in general would be eligible for expungement. Sometimes some judges will only be willing to seal that case because they want law enforcement and the courts to still be able to see it for whatever reason.
And that reason could theoretically be the safety of law enforcement, I think, right?
Correct. I think that is often the concern that's stated by the judges. Oh, and I forgot my usual my usual example of just how broad the ability to seal and expunge cases are. Oftentimes people think that very serious violent crimes can't be sealed. And in fact, murder, burglary, and arson are now all cases where a conviction can be sealed. The bar for that, though, is very high. Like I said, it's never guaranteed. So a person with those records really has an uphill battle to prove to the judge that those records should be sealed or expunged. But the potential remedies are really, really broad in this area.
So Lacey, one last thing is a comment from our really fabulous volunteer attorney, Dave Black, who put this note in probably half an hour ago, and I have to apologize because I'm not sure what it relates to, but I'm going to go ahead and read it as the last question, and then you can comment. He says, while a sealed record may be available for obtaining the disposition, theoretically an expunged record is destroyed and the disposition would not be available.
So
I apologize that I'm not positive when he sent that.
I think that it was probably when I was saying that someone who had one of these records for immigration purposes could ask the court after the expungement for the certified disposition. And it is impounded, and it normally, so let me start over. So the court is always impounding those records instead of completely destroying them. And then no one should have access to them. For these immigration cases, if it's expunged, in theory, you can go in many courthouses and you can open it up to get that certified disposition. You may not be able to do that everywhere. There were some protections built in for the cannabis expungements because some of the agencies that were working on getting this law passed recognized that this was going to be a potential problem for someone with immigration issues. And I apologize, I don't know where it is in the statute, but there were some additional protections for people being able to get a little bit of information if they needed it.
Okay, fantastic.
So I'm happy to follow up. I'm happy to follow up with him as well.
Okay.
Once I can find it.
Great. So we're going to close out our webinar. Give you just a few more seconds if you want to download those handouts on the rental assistance. As you log out, you should get the survey. And Lacey and I both will really appreciate your comments and suggestions. And Lacey, thank you so much. This was really fabulous. I learned a lot, and I know that our audience did as well.
Thank you. Thank you, everybody, for joining us this afternoon.